Welcome back. In a historic move, James and Jennifer Crumbley are each facing 4 counts of involuntary manslaughter following the 2021 Oxford High School shooting committed by their son. He's already been sentenced to life in prison without parole, but this is the first time that parents have been charged in connection with a school shooting. They'll be going on trial separately. Eric sat down with Michigan attorney Jamie White to get his insight about the trials.
All right, folks, we are sitting down with Jamie White, a local attorney here in Michigan, to get some insight on the upcoming trial of Jennifer Crumbley. Now, she is facing 4 charges of involuntary manslaughter in relation to the mass shooting that her son Ethan committed. Now, Jamie, first things first, could you give us a little bit of insight into what she's being charged with?
Yes. So involuntary manslaughter is a felony. It's punishable by up to 15 years in jail. And in theory, what's been reported largely is that those could be held consecutively. In other words, she could do 60 years in jail. I find that unlikely just based on the variables that go into the decision as to whether or not to prosecute somebody consecutively. However, I guess to the basis of your question, what is involuntary manslaughter? It's very different than murder in the sense that you either premeditated the intent to kill another human being or killed another human being in an act that was so foreseeable that somebody could die. You know, classic example is shooting into a crowd, maybe shooting into a particular person. And then we get into the different levels of manslaughter. And so both of these parents are charged with multiple counts of involuntary manslaughter, which in effect means that their behavior was so grossly negligent that they should be held responsible for the actions that resulted.
Now, for those at home who may not be following this trial up until this point, Jamie, could you give us a little insight into the separation of Jennifer's trial from her husband's? Because when this all first started, they were both being tried together as a duo. But
Correct.
About a month or so ago, Jennifer separated from her husband as far as the trial goes. Could you give us a little bit of insight into maybe what the cause of that was?
Let me speak just very quickly generally as to why that would occur. It's very often that people are tried together. It's the preference of the court for efficiency purposes. Oftentimes we have the same witnesses that need to come to court over and over again. So to the extent people can be tried together for behavior they acted in concert, it makes sense. Where that falls apart is when the 2 defendants have what we call antagonistic defenses. In other words, one person is alleging the other person is more culpable. And while Ms. Crumbley's counsel made the decision, this is something that could have been prompted by the court or even the prosecuting attorney, because this is certainly an appealable issue. You have a right to cross-examine witnesses against you. And if somebody's pointing a finger at you, you should be able to cross-examine them. And you can't do that in a criminal setting where they're sitting accused because you have a right to remain silent. So that's the essence of the conflict. It was brought by Mrs. Crumbley's attorney. The basis for that, I honestly think it could have been just a mutual decision, or in fact, the parties have decided that one person is more culpable than the other.
Now, this is really one of the first cases that the United States is seeing where parents are being held accountable for their child's actions. What type of lasting effects, Jamie, do you see this case having, and how may this affect our legal system moving forward?
That's a great question. And I think that there's been a little bit of people have gotten over their skis a little bit in this being the first case. This is the first case where we've seen a mass shooting where parents are then held accountable for people that unfortunately died in the course of that mass shooting. But we certainly have seen cases where parents have left weapons accessible to children who ultimately hurt themselves or maybe hurt another person. Gotcha. We certainly have seen situations where parents sanction a party, where somebody leaves that party, the children were underage, and somebody became, hurt through a drunk driving. And there's more examples. So It's an important point to make that this is not the first example of a parent being held responsible. But it is unique in the sense where, I think our country, in large part, whoever you ask on whichever side of the aisle, are perplexed and confused about why this keeps happening. And the idea that the Crumbleys at least had an opportunity, I think reasonable people can agree they had an opportunity to prevent this, brings this to the forefront. If you buy a gun for a 15-year-old, are you responsible for the acts that he carries out? I would suggest that you are, but when you pile on the idea that there was, evidence to a large degree that this young man was troubled, and they still allowed him access to a weapon, makes them particularly culpable.
Now, do you think this is going to change any of the laws going forward? Because with these 4 charges of involuntary manslaughter and there not being a case similar to this one previously, do you think any changes to our law system are going to take place to hopefully address a parent's responsibility to not give a firearm to a 15-year-old with well-documented mental issues?
I do think we're going to see several proposals. And let me just again first say, we already have a law that says you can't buy a weapon for a 15-year-old. That's already against the law. And I wouldn't be surprised to see the federal government come in after this trial and hold them accountable for what we commonly known as being a straw buyer, buying a weapon for somebody who otherwise wasn't qualified to do so. But in the broader scope of your question, I do think we're going to see a different level of accountability. We're already seeing that to some degree across different states, including Michigan. And, how broad does that become? We'll see. But certainly keeping firearms secured and locked place, and making sure that young people are at least being evaluated when there's credible reports from school authorities that not only is there a problem, but their problem is suggesting that they're drawing weapons and intending to hurt and kill people. I think we're going to see a higher level of accountability so that this question going forward will be more defined for the courts.
Gotcha. I guess that's where I was going with that is, will this be better defined so in the future we have more of a straightforward path? Jamie, thank you so much. It's always wonderful to get your insight on these very complicated topics. Jamie White, an attorney here in Michigan, giving us insight on the upcoming Jennifer Crumbley trial. Jamie, thank you so much for joining us today.
Thank you for having me.